under the Porter Act, and to whose detriment? Is it to the public? Is it to the victims who have been identified and charged? And what is our role as the law society and practitioners within this space and the members of the public, perhaps, going forward? Thank you.
Thank you very much. We gave a little bit of leeway to Mr. Manwa because he had missed the first round. Thank you very much, Chairman Manwa. Before we continue with our questions, may I recognize the presence of today's audience? I can see my very good friends from across the civil society, very good citizens of this country who have been standing forthright and boldly to defend the civic space. Thank you. Thank you very much. This country cannot thank you enough. The citizens of this country will be forever indebted for what you do on the streets in terms of advocacy and helping to stand up for civil liberties. Thank you very much, gentlemen and ladies. Now, I want to invite a comment from my good friend, President Irongo Houghton. What would be your comment, sir, to judicial officers? Because we have looked at the DPP that we all have serious concerns with, and we will go back to them. We will not tire. I want you to give your comment to judicial officers, these magistrates, these judges who are trying these cases. What will you remind them of in terms of their obligations under the Constitution? What should they do? Over to you.
Thank you. Great question. I think there are three things that I would offer to them, and I don't know if they're listening. Some of them may be joining us, anonymously tonight. The first is that the entire purpose of POTA, the ATPU, the National Counter-Terrorism Center, was to essentially protect our freedoms. If you think about terrorism and the acts of terrorism, what do? They essentially try and reduce the constitutional freedoms for women. They try to reduce the participatory nature of government. They collapse representative democracy into autocratic or even authoritarian regimes, and they use fear as the primary currency for which they govern. And I think, as Israel said, it would be almost tragic. I mean, I can't put it even stronger than that. It would be so tragic if we used the Prevention of Terrorism Act essentially to threaten our constitutional freedoms and our rights. It's almost like using a tool that was designed to protect the Constitution to actually destroy it. The second thing, so I would urge caution by not just the judicial officers, by the investigators and the prosecutors, because essentially what they are doing is they're flirting with a very dangerous, practice. The second one is really thinking about what does the misapplication of counterterrorism do to societies. Now, we know from the so-called Operation Usalama Watch in the neighborhood of Eastleigh back in 2014, 2015, that essentially what it did is it generated a sense of resentment, a hatred for the government, and a disrespect for policing, because thousands of people were rounded up purely on the basis that they were Somali, and they were charged, or rather they were held in Kasarani police station, Kasarani sports stadium for several days. And what was supposed to be an anti-terrorism operation turned out to be, at best, a very poor immigration strategy to repatriate people who were in the country without documentation. Counterterrorism that is used unlawfully radicalizes populations. It reduces credibility in the rule of law, and it actually destroys the capacity of courtrooms to be seen as spaces for fair representation and fair trial. So I think that will be the second message to the judicial officers. The third one essentially is that for the people who go through these processes, people who, let me just think about this in three scenarios. And of course, we have to speak in the context of probabilities, because we actually don't know what may have happened around Kikuyu law courts, what happened around Mayago police station or Matu or any of these places. But you could have four types of suspects that were picked. People who were essentially peacefully protesting and were swept by police officers and arrested. You have people who perhaps participated in the burning down of those public utilities, and of course, you know, the burning of a law court is a very serious matter, because if you think about what is a law court is a place where people go to seek justice. In that court is not just buildings. There are files, there are claims, there are calls for justice, there are cases that involve GBV, there are cases that involve inheritance dispossession, and various other things. So these are important institutions. A police station may, because of our, you know, the last few years of police violence, seem like a place that does not deserve to be respected. But if you think about it, without police stations, even with the kind of violence we've seen, what might we have in communities that have high levels of crime? So I think it's important to recognize that you have several categories of people that have been swept up in the 71 that have been announced, that have been arrested and are being charged under terrorism charges. And I think what we have to argue is that it is not enough for the I guess, the director of public prosecutions to charge people communally. Every single person that comes before that court of law has their own story to tell. They have their own defense, and they must be heard individually. And which, if we do not respect, takes us back to the Kunimu punishment that we saw in the 1950s against the Mau Mau and the Keniland Freedom Army. But we cannot see a communal approach to judicial practices at this time. It has to be on the basis of our laws, and it has to be on the basis of individual culpability. And every single one of those individuals must have their right to bail, they must have their right to legal representation, access to their families, and also a fair trial. So I would probably give those three levels of, I think, those three pieces of advice to the judicial officers that are listening to us this evening.
Thank you very much, my brother, my good friend, Mr. Rongo Houghton, for reminding us of the important principal provisions you need to stick to the Constitution. Abner, I don't know if you're with us. Abner?
Yes, I can hear
Abner,
you.
Article 157. This one is the article responsible for the creation of the Office of Director of Public Prosecution. It says that in exercising the powers conferred by this article, the Director of Public Prosecution shall have regard to public interest, the interest of administration of justice, and the need to prevent and avoid abuse of legal process. You were a litigant, you were in court without fear or favor. Do you think that the office of Director of Public Prosecution in approving these charges against Kenyans in the manner they do? I am made to be aware that prosecutors are not individually signing on to charge sheets, which is another problem. Is the DPP living up to the constitutional expectation under Article 157.11? Over to you, Abner.
Hello, you can hear me?
Yes, we can hear you, Abner. Just unmute yourself. Is Abner here? Can anybody hear me?
I think he needs to unmute himself.
Okay,
He's
Abner, can you
muted.
unmute yourself? Abner Mango? Oh, has he been directed towards Karura. Abna, are you here? Okay, Manwa, as no, let's go to Tali. Tali,
Yes, I'm here.
as we wait for Abner to sort out his audio,
Yes.
why don't you take up that question, the question on Article 157.11? There's a constitutional test that should guide the conduct of prosecution by the DPP. Is the DPP, my good friend and brother Renzo Nigonga, abiding by Article 157.11 of the Constitution?
You can hear me now?
Abner, are you here?
Yes, yes. Can you hear me?
Okay. Are you ready to proceed with the question? Then we'll come to you,
yes.
Dali.
Okay.
Yes,
I'm happy.
I'm
Go
ready.
ahead.
Yes, I'm ready to proceed. So thank you, and I'm very much safe, at least for now. Thank you for expressing your concern. Now, uh, that has been a big question that is being fronted now that we are living in extraordinary times where citizens are facing charges of such magnitude. Now, remember, these are very young citizens. If you look at the age, most of them, no one is barely more than 25 years old. This is the future of this country. Now, just from the reading of that name, is the Office of the Director of Public Prosecution, which, as stipulated under Article 157, should be an independent office that should not seem to take any directions from anybody. It is a constitutionally independent office that should not have any directions from anybody, including the executive, the legislature, or the judiciary. Now, other than the constitution, the DPP as well, under the ODPP Act, if you look at Section 4, the DPP is also still entrusted or enjoined to still act in a manner that, one, promotes public confidence and in a manner that protects public interest. Now, public interest is an issue that has also been argued, and people are like, look, you cannot involve public interest when it comes to matters of criminal litigation. But since the enactment of the Kenyan Constitution 2010, certain principles were engraved in the Constitution, and Kenyans were very deliberate on what they wanted. For example, power to the people, as the sovereignty of the people, as enshrined under Article 1 of the Constitution. All sovereign power belongs to the people. Now, the Bill of Rights. These are rights that Kenyans wanted to specifically enjoy. And these are rights that include right to life, right to property. And all these rights ought to be enjoined without limiting any other person's right. But for this particular case, we are seeing grave breaches that are not being addressed. For example, rights of an arrested person to be arraigned before courts within 24 hours. We are seeing cases where Kenyans are being held for more than 24 hours. And this is being orchestrated in a manner and style that is very suspect. For example, you are arrested at 10 in the morning, but you are booked late into the night. So that the argument would be that you are booked late into the night and you are being arraigned later then the 24 hours was at night, so the only logical time would be the next day in the morning. But the 24 hours is a maximum, not a minimum. So that if within 2 hours I can be presented to court, the police or, yes, the security forces should not exhaust the 24 hours. The 24 hours is a cap. So that even if I'm arrested at midnight, then first thing tomorrow morning would be my arraignment in court, whether the police are ready with their police file or not. So that if I'm arraigned, then the police would be saying, we need, say, we're doing a miscellaneous, we need, say, 1 more day or 2 more days with this suspect in custody for us to be able to conclude our investigations. But still remember, even at the point of arrest should not be done until they are certain of whatever charges they'd want to prefer. So the manner and trend of which we have seen, for example, at Kahawa low courts, based on the events of 25th and 7th, there is a similar pattern because the similar actions are being treated the similar way. And unfortunately, we are also seeing even pronouncements in terms of rulings, say example, on bail, is being ushered towards a certain direction. They look more of a copy and paste. But we have confidence in is that the judiciary should stand up and act as the last point of call and the last line of defense of these innocent and vulnerable citizens. Now, for example, setting excessive cash bills of say up to 300 and 500,000 beats the essence. What the constitution provides for example, for purposes of bail and bond is to secure attendance. Now, once as a citizen you're able to establish, for example, you have a place of work, you have residence, you have family, then what should be considered will be now putting in measures that will be able to secure your attendance of court, not for your continued detention behind bars. So, in as much as we are having our issues, which perhaps might call for a filing of, for example, a petition, so that we can be able to have certain interpretation of this, for example, the law, then we are yet to see the independence of this office. And we always insist that Article 157.11 must be read as is, because the rider to that article is that the public confidence and interest in which the DPP should act is in a manner that prevents abuse of the court process. That is what we are trying to really protect. That even if people are being arraigned, people are being charged, the law provides for that, for the right to fair hearing and to face trial. But that should be done in a manner that should not be seen or deemed to be an abuse of court process. That includes putting in punitive measures, ensuring detention, yet every person is considered innocent until proven guilty. Thank you.
Thank you very much, Abner Mango. And you brought in the issue of arrests and these requests for persons to be detained for inordinate days uh, before so as to conclude investigation, which sits us at odds with a decision of the High Court in Republic versus Sudi. And I believe this decision of the High Court binds these magistrate courts. In that decision, Justice Ngugi stated emphatically that you cannot arrest somebody having not completed your investigation. That's a constitutional law provision. You look at also Article 29. You look at the Prevention, the Persons Deprived of Liberty Act. These are all provisions of law that should guide these magistrates. Tali Israel, your judges, your magistrates, the ODPP, are they abiding by the oath? Are they abiding by the Constitution? Over to you.
Thank you. Judges, magistrates, and in this instance, magistrates, they have an oath of office which they are supposed to adhere to. And for them, say that unlike, for example, the DPP that has discretion to charge, although that discretion is not to be acted blanketly, a magistrate does not choose who is brought to him or her. Suspects are brought to them. What they choose is how to handle those suspects. And among the things then they're obligated to do is to ensure that at the very basic, those persons are entitled to minimum guarantees under Article 50, and that Article 49 at the time of arrest was complied with, considering actually that a fair trial is a non-derogable right. So at the very basic, and we have always had this conversation on whether human rights questions are questions that are reserved for the High Court, but it is already settled that even in the magistracy, the magistracy cannot ignore questions, for example, of Article 25. They must always ensure that that test is adhered to. On establishing that, then a suspect comes, a suspect is arraigned. then a bail and bond is opposed. The magistrate has to be guided by the criteria. Let me start with bail and bond, then I'll go to the pre-charge detention. There is a very specific criteria that is right now tried law on considering whether to grant or deny bail and giving bail at reasonable terms. Considering that you don't give bail to punish, this person is still innocent until proven guilty. This person still has the rights to freedom. And all offenses in Kenya are bailable. All offenses in Kenya, including terrorism, including murder, is a bailable offense. So a judicial officer properly exercising themselves should always ask, is this person at flight risk? Is this person going to interfere in investigations in any way? Is this person going to interfere with witnesses in any way? If the answers to those questions are no, and then the other questions would be, what then are the bail and bond terms to grant? And away from this fiasco with the people being charged with terrorism, under normal offenses under the Public Order Act, we know comparatively what amounts of bail have always been granted, 10,000, 5,000. A judicial officer who would come and grant bail of 100,000 clearly has not properly exercised themselves. And that can clearly be seen. It is facts speaking for themselves. Even in now charges such as terrorism charges, a judicial officer shouldn't grant punitive terms that then would condemn this person to go to remand, and then they stay in remand for long. At the end of it, the charges are either dropped or they are acquitted. One would argue they can pursue malicious prosecution, but we know the feasibility of that in this country. So a judicial officer should always balance. And I believe that in the modern context we are in, human rights are sacrosanct, and the judicial officer should always be guided in all actions they do for the human rights of the persons brought before them and balance them with public interest. Now, secondly, with respect to the question of pre-charge detention, and as you've clearly highlighted, the Oscar Sudi case was very emphatic on pre-charge detention. I do not understand why we still have a pre-charge detention being entertained. And there might be instances, and we can always agree, isolated instances, because I meant to understand. For example, if we were speaking in the proper terrorism context, forget about these terrorism things that are being trumped up, but terrorism by its nature, where we have the national security at risk, I would have excused a judicial officer who would have allowed keeping a suspect, because then as investigations are done, because this, for example, would serve to disrupt planned attacks or planned destruction that would have occurred. But now an action has already occurred. Like I saw another case, although it ended up being dropped, but I saw another case where there was a plan to request to hold a suspect for 21 days, where the suspect is being accused of uttering certain statements they were calling alarming statements. Now, the statements have already been uttered. Why would you need to hold this person for 21 days? Can this person interfere with investigations? No. Can this person interfere with witnesses? No. The witnesses in question were DCI officers. So you want to say that as a young Kenyan at 22 years old, having his phone on the hand, tweeting, or rather saying videos on TikTok, is going to interfere with investigations and endanger DCI officers? The answer is no. So as a judicial officer, I think it is important that our judicial officers live within our realities. They strictly adhere to Article 159 of the Constitution that grants them judicial authority and asks them to exercise judicial authority in accordance with the Constitution, in accordance with the fundamental rights and freedoms of individuals. For example, as I finish on that, if I was a judicial officer and a suspect brought before me, what would inhibit a judicial officer releasing the suspect and the suspect be reporting to the police station once or twice a week to assist in the investigation if that is what the police want? so that the judiciary is not seen as having been weaponized. Because as our seniors have always, and our forefathers have always said, the judiciary remains our last standing person in the face of the greatest impunity. That is what I would say with respect to that. Thank you.
Thank you very much, Tali Israel. I hear you to be saying this, that we have weathered the storms in this country by a judiciary or judicial officers who have balked against the grain, judicial officers who stood up for principle. In mind, we have Justice Madan, Justice Willie Mutunga, Justice Nyakundi, Justice Chacha, with Magistrate Dolfina Alego, we have Ben Marke Kubi, these magistrates and judges who are doing right. And we wish to thank these judicial officers who are standing up for what is correct. Their colleagues are urged to take cue and do what is right, because when history is annulled, we will ask you, where were you when the Constitution was being rapined? I have been seeing this hand up for some time. Actually, there are two. I'll want to hear from Wajiro K and somebody by the name Redemptor Mwikali. Wajiro, you have 2 minutes, followed up by Redemptor. Then we will take one more, and then we wrap up. I can assure you, this is only the beginning. My president, Faith Odhiambo, assures me that we are going to have a sequel to this. We are going to have more town halls by the LSK on these particular questions. Wajiro, over to you.
Thank you. I hope you can hear me.
Yes, we can.
Oh, thank you. Mine is, I'm asking this question as a layman because I have no legal background, but I'm just asking as that young Gen Z who has just been arrested by a policeman and they're taken to a police cell and they're told that they'll be charged with terrorism. Now, first and foremost, I think that in itself is very frightening. And at that point, this young man or this young lady does not know what their rights are. They might not have access to legal advice at that point. And then we don't know what process goes on when they're being processed, whether they're being questioned, what they could say in that moment when they're very, very scared. Now, the other thing I wanted to ask is what the threshold is for charging a person with terrorism act in as opposed to a criminal charge, whereas we know that terrorism has a specific definition. Now we have these young people, they're taken to police cell, they're held there, and the investigation is supposed to proceed. Now, DCI or the Anti-Terrorism Police needs to do an extensive investigation in order for them to prove these terrorism charges. Now, we've seen in developed jurisdictions where they look at their online history, they go into their home, they take their computers, check if they have any affiliation to any terrorism groups, whether they have any fixed ideologies. And because these young people are now being charged as groups, is the government now saying that in Kenya we have a terror group? And in that case, is the government now charging them as individual terrorists, or are they being all charged as a Gen Z? Is Gen Z movement now being classified as a terror group? Those are some of the questions I'm really wanting to find out. And then lastly is the implications.
The final one, Wajiro.
Yeah, just the last one. The implications of these charges that the government is loosely handing over internationally when these young people want to apply for visas, want to travel abroad and work. So how is it going to affect them moving forward? Because even if they're not proven guilty, they will still have that tag on them. For example, if they want to travel to the US, that is not going to work for them because they will not be allowed to travel to the US just because they've been, suspected of terror activity. Thank you.
Thank you, Wanjiro. Redemptor, over to you.
Thank you very much. Good evening, everyone. I salute the champions of justice on this space, the advocates for a just society, and the human rights defenders that are in this space. And I want to use this opportunity to cry as a cry for help for my hometown, the town of my youth, and just to disclose that Matu is home to a former police commissioner, and Matu does have criminals. Matu is also very close to Kidimani, where we have Yatta GK prisons. And it is on these spaces that I've had allegations that in a different town, inmates or petty offenders were released just before June 25th to infiltrate the protests. So that if there's an investigative journalist in the house, that is news for you. Now, for the human rights defenders and for the lawyers, what needs to be investigated are allegations that I had again on space about these young people accused of terrorism being moved from different cells, and their allegations of they have been tortured. Now, my curiosity for this case, and I'm taking Matu as a case study because that's my hometown, that in the past, the wife or the family of the former police commissioner was attacked, and she was injured, very badly injured, and the culprits were caught within hours because it was an embarrassment to the police that their own could be attacked. And I think that could happen. It could still happen because that police station is on Garissa Road, as you know, and we are Matu is a few kilometers to Garissa town. Villagers have asked me to describe terrorism, and someone has talked, I think it's Evans or Akili Evans, who has talked about ideology. I have to explain to people what terrorism is. And the closest we are coming to ugaidi tukisema na Kiswahili is Al-Shabaab and Shifta. And so I think we need human rights defenders to washuke wateremke wasaidizi families, because what if one innocent person gets caught up in this and lives are destroyed? So for me, those are the two things I needed to find out, that even as you fight for all the others, there are 10 people from Matu. I don't know if they'll be granted bail. And I don't know who said this. It is better to risk saving a guilty person than to condemn an innocent one. And I think the young people, and I'm also curious very quickly, the videography in all the towns, in all the cases, because I had the government spokesperson or someone called Charles Owino saying Matu had 1,000 people invaded a police station. I've not seen a single video. And one of the people who was arrested is a maize roaster, and that speaks to the ideology. Did he just follow? Was he a vulnerable person? So just to call even Imlu to step down and help people who are shot. And even as we talk about a police station that was burnt or attacked in Matu, let us also remember two young people were killed in Matu town. Thank you very much, and keep up the good work.
Thank you, Redemptor. Of course, I believe, with leave of my president, we sympathize with those that are injured. Our deepest condolences to the families that are mourning. It's indeed a difficult time for the country. Redemptor, the issue of terrorism is usually very emotional, and I can tell you, Nelson Mandela was a terrorist in American books up to 1993. And that's the reason why in Kenya we sought to align the Prevention of Terrorism Act to international standards so that we have something uniform. And unfortunately, that is being abused. Chairman Manwa, I would want you to help us briefly to respond to, because Redemptor's views were mostly comments. Wanjiro has asked 3 questions. I don't know if you could help us with those 3 questions. Then we take one more and we call it a day. I'm sure we are going to have another session.
Chair, thank you. I don't know whether you can reiterate those questions, perhaps, so that we are able to respond quickly.
The first question by Redemptor was basically the lack of awareness on the rights of arrest. People are arrested, incarcerated, they don't know what to do. The second one, the threshold in the Terrorism Act. How do you distinguish terrorism from crime in the other act? like the whatever the penal code. And then the last question is the implications. People are arrested and charged for terrorism. This may have serious consequences in terms of their history. If they seek to travel outside the country, that might raise concerns in the future. Over to you, Chairman.
Thank you so much, Dr. for those concerns. And I think these are fundamental questions, particularly, and I'll start with the last one. The implication of travel outside the country, especially when you've been charged with a crime under the TOPA Act. It's important that we establish why the Director of Public Prosecution, and I think concerns have been raised as to why the DPP deliberately decided to actually allow or approve, because that's a constitutional requirement given to the Director of Public Prosecution to approve charges. And the threshold created under the Constitution, and the reason why we allowed the DPP to perhaps have that mandate, is to scrutinize the evidence that is given and perhaps inform himself or herself as to whether the threshold has been created that if they institute the proceedings, a conviction will be issued. Based on that background, that led to, of course, the Constitution of Kenya 2010 being enacted to give the DPP such powers. The problem is that these charges, as presented, and I think it's important for the members of the public to appreciate that the implications under Porter are far-reaching from the time of being charged. And that's why we are monitoring the charge sheets, because at the end of the day, young people will be presented as a single section within the one of the court stations. Almost 86 people were charged under the offenses under Porter. The implication internationally is huge, and remember, the international community will not care as to whether these were charges presented for purposes of stopping a political process or for purpose of course, ensuring that young people do not go to the streets. But again, the risk and the fear that is created internationally is that you will not be allowed to another country just because you have been charged, not even found guilty or convicted of the offenses charged. And constitutional and criminal practitioners will tell you that 90 or 99% of these charges will be dropped at some point. There will not be convictions. It will be foolhardy of us to assume that the DPP does not know that. So the intention from where we sit is that this is supposed to intimidate and scare people from exercising their rights. But at the same time, if someone was guilty of an offense under the Penal Code, the risks being charged under the Porter Act are huge than the risks being charged under the Penal Code. And so over time, and perhaps as we participate through this process, we'll be able to establish that process. And I want to give Wanjiru some confidence that at some point, because we are monitoring these cases as a Law Society, we have a mandate under Section 4 of the Law Society of Kenya Act, a statutory mandate to participate in these processes and guide courts as to the implication of such charges. I know most of them will be challenged before the High Court in terms of ensuring that those charges do not see the light of the day, and so that the records of these individuals in terms of their integrity, and considering that they did not participate in any terrorism activity in the strict definition of the provisions under the Prevention of Terrorism Act, were not met. To the first question, lack of awareness, I think it's important. Most of the members of the public here check out on the Law Society of Kenya website and, of course, our social media pages. We have done public awareness reviews. We are actually doing this space for purposes of ensuring that the public is aware of the implications of charges under the Porter Act. At the same time, on the implications of the recent charges as presented under the as or perceived as terrorism going forward, and they ought to know that these are serious offenses. And whereas we are participating on the periphery, they need to instruct proper advocates to ensure that they actually help the courts in ensuring that these charges do not see the light of the day. We have no problem the DPP charging individuals under the penal code, and I mentioned earlier the offense under arson, especially on properties belonging to government that has been burned down. We have offenses on robbery with violence of individuals who have been found and evidence has been recorded to have actually committed robbery. We have offenses on assault. We have offenses on, we have all manner of offenses under the penal code. We will not have a problem as the Law Society of Kenya if charges are preferred on individuals who have been found and who the director of prosecution has actually established that there's evidence to that effect being charged under the penal code. The problem we have is the misuse of the terrorism, the Porter Act, because it has far-reaching implications to not only the entire populace or to members of the public, but also to individuals in terms of travel, in terms of employment, because in Kenya, employers also check on your records in terms of the charges you've actually been charged with. And even if you are acquitted, they'll be as skeptical as possible to ensure that they don't employ you until, of course, they are on the clear as to the fact that you did not participate in that process. In terms of the third question that was raised on the threshold in the Terrorism Act, I think the threshold is too high, and this is because this act was enacted because of necessity. And without reiterating what Tali, what Irungu, and what Abner have spoken in terms of the threshold, if you check the definition given under the Porter Act, you will notice that the threshold is too high. Too high to the extent that you cannot just allege that someone committed a terrorism act. It presents different dimensions in terms of the threshold. And I'm happy that I'm not happy, but I'm happy that the courts will have an opportunity to interpret the provisions under the Porter Act and perhaps give directions as to what is the threshold beyond the statutory provisions that have been set out under the Act, so that it is clear to both the executive, the judiciary, and the legislature that this is the threshold as presented through precedent. And I think, Dr. Evans, you will agree with me that we have not had a situation where, in the previous years, where civilians who participate in demonstrations have been subjected to the Porter Act in terms of the crimes. Mm-hmm. This is the first time, and I think we will have an opportunity through the judicial process and perhaps the High Court, the Constitutional Court, will be able to interpret and perhaps interpret the definition of what constitutes a terrorism act. That will and of course that is why the Law Society of Kenya is actually participating in the process of monitoring all the charges in that touch on the Porter. And of course, as we go forward, we'll be able to have more spaces that will be able to highlight and enlighten the public as to what the court has pronounced itself, as to what the court has given in terms of definitions, or any other new precedent that has been created as a result of these ongoing charges. But again, as the Law Society, we will not relent to challenge the Director of Public Prosecutions to do the right thing. It is concerning to all of us that the Constitution, and this matters before the Court of Appeal, as to who is supposed to draw a charge sheet. The purpose of the National Police Services, to the Inspector General and the people concerned with the investigation, is to present evidence through investigation to the DPP. Once the DPP receives this information, they have to review the evidence presented as investigated by their colleagues who have presented this evidence and now inform themselves. You have seen instances where the DPP has refused to prefer charges against certain cases that have been presented before the DPP, for good reason, because the threshold has not been created. The drafters of the Constitution foresaw a situation where, remember, before the 2010 Constitution,
Yes.
the DPP had huge powers, including nolle prosecute at any stage. The DPP would issue a nolle prosecute at any stage. And there was too much political interference. There is a specific reason why the responsibility was given to the DPP to review the evidence and prefer charges. They have to take responsibility for these charges preferred. They have to demonstrate that they had capacity. But again, there are red flags as to why the individual Director of Public Prosecution who's approving these charges failed to mention their individual names. Because you have a professional responsibility, you're a public officer, you have to state that this is the reason why I chose to prefer this, approve these charges.
Yeah.
Thank you so much, Dr. Evans. I think I'm speaking too much. I hope I've answered the three concerns.
No,
Thank you.
thank you very much. I am aware.
Evans,
Wanjiro, hold on. Wanjiro, we are out of time. We have overshot our time by I think 14 minutes. I am very sure that we have burning questions, we have burning concerns. I will beg with you to forgive us for today. We are going to have a sequel. We are going to have a follow-up to this, that I am assuring you. So for today, this was just but a teaser, the first of many. I want to give a few minutes, actually it's a minute each, to each of our panelists before we ask the president of the Law Society to give her closing remarks, and then we will call it to an end. So in terms of order, we will start with Mr. Tali Israel, Abner Mango, Manua Hosea, our co-host, my friend Irongo Houghton, and then we finally go to the president, then we call it quits for today. So Tali Israel, your closing remarks in a minute. You can unmute yourself. Abner, can you hear me? Abner? Irongo, can you hear me? What's happening? Manua?
We can hear you. I think they are all muted. If you can ask that they unmute themselves.
Yes.
Thank you, Dr. You had muted us, huh?
Okay, sorry. Tali, let's proceed.
I would be very brief, and I would start by saying that as a country, we need to know, and as a Gen Z myself, I start by a meme on TikTok that usually says, tough times never last. only tough people do. As a country and as our generation, this is among our tough times. They will never last. Those who came before us lasted through tougher times. I think the resilience needs to remain. Secondly, and most importantly, would be a call to our institutions. The Director of Public Prosecutions is a key and central institution. I urge its independence of that institutions. Our judiciary, our last port of call. I urge our judicial officers to remain true to their oath. Our civil society, clapping for you. Let us continue on that path. Let us continue advocating and fighting for the proper implementation of the rights that we gave to ourselves. Indeed, these tough times will never last. We will last as a country. Thank you, and thank you for the opportunity to speak. Thank you to the audience for listening to me, and have a blessed weekend.
Thank you very much. Tough times never last. Abner Mango. Abner? Is Abner here? Let me just see. Abner seems to... Abner, are you able to speak now?
He has requested for the mic. If you can give him the mic, I think he has tried to join back.
I have tried to approve him. He's here.
I'm here.
Okay.
I'm here. You can hear me?
Yes, we can. Abner, proceed.
Yes. Thank you so much for having you, and thank you to LSK and Madam President for having this session. I can indeed confirm that over the last 2 weeks, personally, and I know as a society, we have received a lot of call to help. We have received a lot of questions. We have seen a lot of anxiety and panic, and this has been caused by the recent actions by the state and the DPP to proceed in the manner which they are proceeding. We, however, call upon all of us to remain steadfast, to remain confident, to remain vigilant, and to continue pushing on. For us, all we are advocating for is for the rule of law and constitutionalism, and we want to encourage and comfort all those families who perhaps have their kin, their loved ones still behind bars, that we shall do all that is within our means, within the confines of the law, to secure at least the release on bail and bond, and even further to that, to see those trials to the logical conclusion. So, Ogada, as you've promised, I'm part of those who are eager to have more sessions. But for tonight, I'll leave it at that. Thank you.
Thank you, Abner. Thank you very much. Chairman Manwa.
Thank you so much, Dr. Evans Ogada, for this session. And I think I want to thank the President for heeding to the demand. Remember, we are holding this session because most of the members of the public requested that we do so. As I indicated earlier, Dr. we have a statutory mandate as a law society to ensure that we do this public discourse to perhaps set the record straight. And we understand that the members of the public have a huge expectation on us to do what we are supposed to do under statute. We have put up a toll number in our Law Society page, and we have received so many concerns, and we continue to receive so many concerns. We have acted on a majority of those concerns, and I think most of the panelists here are aware that we have at least tried to meet that mandate as the Law Society. I ask the members of the public to not to hesitate, but to channel those concerns, continue to channel those concerns that are human rights related. We will be able to be available and participate. We have advocates, our members across the country, in every police station, in every court station across the country, who will be able to assist in the process, especially if you are vulnerable, you are not able to afford an advocate, you're not able to defend for your rights, and you think your rights are being violated. as a law society and as a convener of the Public Interest Litigation Committee, we are actually determined to ensure that we represent those people we think their rights under the Constitution are being violated. We also ask our counterparts at the Director of Public Prosecution to stick to the oath of office. Ensure that you do not allow frivolous or vexatious charges against any member of the public. Because at the end of the day, the role that you are actually serving today, tomorrow you might be a victim. It has been so from time to time. Today you are in the office, tomorrow you'll be the victim. So ensure that while you're in the office, you do what is right. Ensure that you defend the members of the public to the best of your knowledge. Ensure that no individual, and I think Daktari will agree with me that majority of the victims of these processes are paupers, are poor people, poor people's children, who are actually being subjected through a judicial process which they do not understand. As a law society, we relate to those cries. We have a duty. We have no capacity to fight the government of the day, but we have capacity under statute to defend the members of the public to the ends of the day and to ensure that at least they get justice in our courts. To the judicial officers, and I think Tali has spoken to this, you are equally human beings, and I think today we had a judge indicate that I'm a human being. If we appreciate and agree that we are all human beings, then we have to ensure that we judge people according to that human nature. Let's not take a Pharaoh position. Let's not actually be the conduits as judicial officers to undermine the Bill of Rights. Let us be human beings and ensure that the charges presented before you, if they are erroneous, if they are politically instigated, let us decline to proceed with those charges. To the executive, there is nobody who's fighting the government of the day. The members of the public are raising concerns. The most important thing any government in the world should do is to listen to its people and perhaps give proposals as to how they can remedy the situation of its people. And I think once we have that in place, we'll be able to have a proper society. Thank you so much, Madam President. Thank you so much, Dr. Evans Ogada. Thank you so much, Irungu. Thank you so much, Abner and Tali, for participating in this process. I think the entire process falls under the Public Interest Litigation Committee, which I convene. We have seen a lot in terms of human rights abuses. We hope that in the fullness of time, we will be able to have a society that is understanding, where we can speak to each other as human beings. Thank you.
Thank you, Chairman Manwa. Over to you, President Irungu Houghton.
Thank you very much, Evans, and just want to close by just thanking the Law Society, the Platform Magazine, and of course Amnesty for convening this conversation. It is a timely conversation, it is a necessary conversation, and particularly given the comments that we've heard from people, it is one that I think we should have a sequel, as you've said. To those of you, the 500 or 50 or so that are on this call, wherever you are in the Republic and abroad, to the Social Justice Center leaders, I see you, to the members of the media and the correspondents and lawyers and all the active citizens on this group, just thank you for joining us, publicly or anonymously as well this evening. I particularly wanted to point out somebody who I think has been tremendously courageous and has faced much of the terrorism, culture, or the weaponization of terrorism against the call for democracy and the call for human rights and good governance, and that is the president of the Ugandan Law Society, who's with us, Isaac Semekade, who has joined us and has been sitting into this conversation. Courage, comrade. We are also going through similar times like you, but we continue to hold our constitution at the forefront of our work. I think I wanted to touch on this issue of people who have been charged with terrorism charges and whether they will be able to get a job or whether they will be able to travel abroad and so on. And just to say that it is the convictions that usually tend to be the most dangerous, I guess, obstacles for people applying for jobs and so on. And sadly, if this generation of young people must walk around with rulings that exonerate them or judgments that exonerate them as they apply for jobs or as they apply for visas, then perhaps that is the price that some will pay for a new and democratic country. But I think the other point that is important to note is that the misuse of Potter could trigger a review of Kenya's relationship with a number of partners, foreign development partners that have been funding, have been working in collaboration with our counterterrorism agencies. Last year, something like about $380 million was the contribution that foreign countries were making to our counterterrorism efforts. And I think if the Prevention of Terrorism Act and all the architecture is now going to be weaponized against peaceful protesters or even people who have been accused of arson, then I think there is a bigger challenge for the country in terms of national security as well. Lastly, I just want to say that our hearts and minds must remain with all the victims, the 43 victims at least, of the violence that took place at Sabasaba. Yes, we can be concerned about property and about the attacks on judiciary and the attacks on the police, but I think we have to say it's not just Bridget and Jockey that our hearts are crying for at this time. It is the entire generation that seems to be condemned, to this kind of violence. So for those of us who will continue to provide legal assistance, more courage to you. For those of us that will go to the courts and be trial observers, more courage to you. It is important that the light continues to be seen in Kahawa court, law court, and I think with courage, solidarity, and a calm resolve, we too shall pass through this period a stronger country and a more unified country. We often forget that even acts of terrorism produce solidarity. If we remember the solidarity or the courage that came, the compassion that came from those informal kiosk owners who brought food for our security officers or our paramedics at Westgate, or the bravery of Abdul Haji, or the Imam Salah Farah, who stood up in a bus that had been stopped by terrorists and said, "You will have to kill all of us, or you have to leave us alone." He was a Muslim, wasn't being targeted. They were looking for Christians, and he took a bullet rather than betray the Christians that were on that bus that day. That story is in a short movie which people have not watched called Watu Wote, is worth watching. It's the incident of 2015. So I think we have to say that through this also we will see greater courage, greater solidarity, and greater unity as a country. Thank you very much, Evans, for moderating us so well.
Thank you very much, President Houghton Nirongo. Always a pleasure, my elder brother. Madam President, over to you for the final remarks.
I want to say thank you to Irungu Houghton, to Manuel Ser, to Abna Mango, to Tali Israel, amongst all the other speakers, and of course to yourself, Evans Okada, for being present and sharing. The aim of this is not only to educate our youth, and particularly the bigger worry that we have about radicalization of the youth, and also to understand what the law provides, how to protect yourself, and also the kind of challenge that we'll be facing. But I'm always encouraged that in greatest adversity, there's always hope, and there's always inspiration, particularly from the youth. And I want to say that the reality is we are facing challenging times. However, even amidst the challenge, the courts are never silent, and we'll keep reminding them to hold them true and account to the role that they must play as the last bulwark.
of the society. Um, I express my heartfelt condolences to all those who were killed during the Saba Saba protests, during the Gen Z memorial protest against the killing of the young lady who was raped and killed at her home, protests on the killing of Albert Ojwang, amongst others, that we continue to raise hue and cry. And we continue to see the great humanity and in the people, even families like for Boniface Kariuki. The first call to action for the family was to ask the National Police Service to ensure that they restrain themselves because they did not want to see another family suffer the same fate. And it behoves us to call for accountability, but also to protect ourselves, to be vigilant, to ensure that we exercise our rights within the law to prevent unfortunate events from happening. And it calls upon each and every one of us to remember that if we're not vigilant, if we don't hold others accountable, today you may think you're safe, tomorrow it'll be you. And so one, we are responsible for one another, we're responsible for this nation, we're responsible for this country, that we ensure that we protect our nation, we protect our country, but also we hold the various institutions accountable. It's because of this accountability that we see the growth, we see democracy thrive, and we protect even the hard fought democratic principles that those who came before us have fought time and time immemorial for us to enjoy the freedom of expression, of assembly, and so many other rights we enjoy in today's Bill of Rights. And so the encouragement is others have gone through it, we are going through it, but we want to come out stronger and better as a nation, as a country, as one loving people of Kenya. My resounding call is let us not allow ourselves to be divided on tribal lines. Let us not allow ourselves to be divided on lines. Remember that we are one nation, we are one people, and we owe it upon ourselves to see the growth and betterment of this country. Thank you so much.
Thank you very much, Madam President, for your remarks. The 500 plus individuals who have been with us over the last hour, thank you very much. Special mention to my brother, colleague from Uganda, President Isaac Semakande. Thank you very much, comrade. It's good to see you around here. Tony Gashoka, this is a name that we Kenyans know. Thank you very much, Mr. Gashoka. We appreciate your stellar contribution to what we have in Kenya today. I saw Shakira and leaders of the various social justice movements. Thank you very much, colleagues and comrades on the streets. We appreciate what you're doing. Thank you to the platform led by our chair, Gitobu Manyara. Thank you, President LSK and the LSK fraternity. Thank you. Amnesty International led by President Irongo Heaton for having hosted us today. The parting shot and the parting words to the ODPP, the magistrate and judges, those of you who are in power today, the words of Martin Niemöller, that German priest. First, they came for the socialists. I did not speak out because I was not a socialist. Then they came for the trade unionists. I did not speak out because I was not a trade unionist. Then they came for the Jews. I did not speak out because I was not a Jew. Then they came for me. There was no one left to speak for me. Tomorrow it shall be you who shall speak for you. Ladies and gentlemen, thank you very much. See you on this next space event.